We are present this morning in the matter of State of Ohio versus Sherwinlia Clark. This is case number 25 CR 1598. Present open court this morning is the defendant with his attorney, Chad Mulkey. We were last here for a pretrial on March 30th. At that time, we did discuss some of the details of the case, and since then, I've had an opportunity to discuss this case extensively with Mr. Mulkey. There was some discussion as to the defendant providing some certificates that would potentially rise to the level of negating the criminal charges in this case. I did have an opportunity to review some of those certificates from the defendant through his counsel. Ultimately, after looking at them, the state's position is that it did not negate any of the criminal offenses, and so from that, the state did extend an offer whereby the defendant would plead guilty to count 1 of the indictment, which is felony 3, having weapons while under disability with the attached forfeiture specification. The remaining counts would be dismissed upon sentencing, and that does come with a commitment to community control as a recommendation from the state, provided that the defendant does not violate conditions of his bond, commit any new offenses, and appears in all hearings between now and the sentencing. I believe that any of their certificates that the defendant did provide at this point would just be mitigation presented on behalf of defense, but I defer to them on that. But I just wanted to address that because that was something that was brought up specifically at the pretrial, and I don't think there's anything else from the state as it pertains to today's hearing. Oh, well, it's my understanding the defendant wishes to accept that plea, by the way, and he will be withdrawing his not guilty plea and entering a plea to guilty to count 1, the felony 3, weapons under disability with the forfeiture specification.
Thank you. Mr. Mulkey, is all that accurate?
It's all accurate, Your Honor. I've had several conferences with my client, and everything the state has recited has been true and accurate. My client understands, as the state has referenced, potential mitigating factors. Nevertheless, he intends, is my understanding, to accept full responsibility today, and I anticipate a guilty plea as recited by the state, Your Honor. Thank you.
Thank you. And Mr. Clark, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here?
Yes, sir.
You know, you can be seated at this time. I don't interpret that as any disrespect. It's much easier to be sitting down when we're doing all this. So you heard what they had to say?
Yes, sir.
They indicated to the court they believe it's your desire to withdraw your previous entered plea of not guilty to count 1 and plead guilty to that charge with the forfeiture specification.
I do.
The other 2 counts would get dismissed. We would continue the sentencing to a future day to get some evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they believe is the fair and, well, I'm sorry, there is a joint recommendation. My apologies. The part of the agreement that you reached through your attorney is that there will be a joint recommendation that you be put on community control sanctions, sometimes referred to as probation, as part of the negotiations that took place. I'm sorry about that. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes, sir.
Well, before I can accept your guilty plea, then I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, all the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you would like a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Well, let's get started then. How old are you, sir?
60.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
Not at all.
Are you a U.S. citizen?
I am.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No, sir.
What about in the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
Nothing.
Very good. Now, you should have received a copy of the indictment in this case. That's the document that sets forth the specific charge you're accused of committing. It looks like you probably got that, beginning of March, maybe a couple months ago.
Yes,
Remember getting that document?
Yes, sir.
So you had a chance to look it over? You've had a chance to look it
Yes,
over?
sir. I have had a chance to look over.
Well, in that indictment, you are charged with 3 counts. Pleading guilty to the first one, so we're going to review that first count. In count 1, what's alleged here and what you'll be admitting to is on or about November 2nd, 2025 in Wickliffe Lake County, Ohio, that you, not having been relieved from disability under operation of law or through legal process that you knowingly acquired, had, carried, or used a firearm or a dangerous ordinance, and that you were under indictment for, you previously have been convicted of a felony offense of violence, that being burglary and or felonious assault in Cuyahoga County back on October 29th of 2008. That conduct constitutes the offense of having weapons while under disability, and it's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in this count?
I do, sir.
Any questions for me about it?
No question at all.
Now, the charge also carries with it what we call a forfeiture specification that alleges during the commission of the offense you had in your possession a Ruger SR9C pistol with a magazine and ammunition, which were used as instrumentalities. Instrumentalities is property that's used to facilitate the commission of an offense. And here it's alleged that there were instrumentalities to commit the offense of weapons under disability. The whole point of this specification is that you forfeit any ownership interest you have in that property. It doesn't increase any potential consequences or other penalties you face, but you forfeit your ownership interest. You understand that?
Yes, sir, I do understand.
Any questions about it?
None at all.
Now, there are 2 other counts of this indictment. Those are both being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
Any questions about those 2 charges?
None at all.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you are giving up. And you, first of all, have the right to have a trial. And the trial could be to me as a judge, or I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also do have a constitutional right to have a jury trial, and a jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then the jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. Unanimous means all 12 of the jurors would have to agree together, one way or the other, as each charge whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial?
I do.
Now, if we had a trial, the prosecutor here would represent the state of Ohio, and he would have what we refer to as the burden of proof. By having the burden of proof, what that actually means is that it's his job, or he bears the responsibility or the obligation, the duty to prove you guilty before you can be found guilty. You're presumed innocent of all the charges, and the presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
I do, sir.
Now, we talk about this burden of proof and proving you guilty. That burden is what we call proof beyond a reasonable doubt. And that's the highest burden there is in our justice system. And what it actually means, it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of the charge I just read to you beyond any reasonable doubt before you can ever be found guilty of that charge at a trial. Do you understand that?
I do.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
I do. I understand.
Sorry?
I understand, sir.
Okay. Now, in order to try to do that, if we were to have a trial to prove you guilty, the state would bring witnesses into the courtroom to testify for the state, and they'd answer questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. So he could ask him anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
I do, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you do have a right to do that if you wanted. Do you understand that?
I do understand that, sir.
And you further can request the court issue an order. That order we call a subpoena. What a subpoena would actually do is force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. You understand that?
I do understand, sir.
You realize you're giving up that right?
I do.
Now, you'd also have the right at the trial. You could choose to testify on your own behalf if you wanted to. But you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
I do.
So what that actually means is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial. If you didn't want to, I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes, sir.
Further understand that if you went to trial and you were found guilty of this charge, you'd have the right to appeal or challenge that guilty finding to another court, a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
I do, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you've given up by pleading guilty. Any questions?
No, sir, I fully understand.
Do you still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir, I take full responsibility.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
I do, sir.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 3rd degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of, strike that, the minimum is 9 months, the maximum is 36 months, or there's increments in between of either 12, 18, 24, 30. So if I felt a prison term was warranted, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve. You understand that?
I do, sir.
Now, are you currently on probation or parole, any supervision to any other courts or agencies?
No, sir.
Do you have any other criminal charges pending against you anywhere?
Not at this time. I got a case at Willoughby Court, a separation thing going with me and the ex. I got to deal with that on tomorrow.
Is it a criminal case?
It's domestic case. Yeah.
Okay. Well, here's the only reason I asked. Do you have any felony charges pending against you?
No, I don't.
If you have another case that you get sent to prison on before you come back here for sentencing, I could run a prison term consecutive to that, which
Yes, sir.
means one after the other.
Yes, sir. I don't have nothing like that.
Okay, all right. That's the reason I was asking.
Yes, sir.
If a prison term was imposed in this case, upon your release from prison, you could be put on what's called post-release control, sometimes called parole or PRC. It's a period of supervision you would be on after you completed the prison sentence. And in this particular case, it could be up to 2 years. You understand that?
I do.
And if you were put on PRC and you were violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
I do.
Now, aside from the possible prison sentence, there's other sanctions that can be ordered. You could be fined, in this case, up to $10,000. You could be ordered to pay court costs. You can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable in this case. Do you understand that?
I do, sir.
Further, as I alluded to earlier, any right, title, or interest you have in the firearm that was the subject of this case, as well as the ammunition and the magazine, that would all be forfeited to the state of Ohio at the time of sentencing. You understand that?
Not a problem. I do understand, sir.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible. Prison is not mandatory with this charge or required. You're eligible for probation or what's called community control sanctions. Do you understand that?
I do, sir.
Do you understand that just because you're eligible doesn't mean it'll automatically be put on probation? It means I'll consider that if that's what you're requesting, and it appears you are. I'm going to look at all the information that gets presented to the court, then I'll make the decision I believe is the right thing to do. Do you understand that?
I do understand, sir.
Now, if you are put on probation, it could be up to 5 years of supervision, as the judge had the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months, the condition of probation. You understand that?
I do, sir.
Further, if you are on probation and you ever violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could order more restrictive sanctions against you, including an order that you serve time in jail, county jail. Or I could terminate your probation and send you to prison at that point. And if I did it at that point, again, it could be that same range I mentioned earlier, 9, 12, 18, 24, 30, or 36 months. And that could also be consecutive to any other prison sentence you may be serving if there's some other new case that comes around, or that you're being sentenced to at that time for a new case. Do you understand that?
I do, sir.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer can speak on your behalf. The prosecutor can make recommendations. You understand that whatever the lawyers say or whatever anyone says, quite frankly, at the time of sentencing regarding what they're recommending, what they think the sentence should be, it is just what I said. It's a recommendation. I'm not obligated to follow that if I didn't think that was the right thing to do. Do you understand that?
I do understand, sir.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
I do.
Do you still want to plead guilty?
I do.
Have you had enough time to talk about this case with your lawyer, have him review the reports with you, discuss the issues, answer any questions you may have?
I have.
Are you satisfied with his advice and counsel?
I'm totally satisfied, yeah.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering your guilty plea freely and voluntarily?
Freely.
Okay. All right, do you have any questions for me then at this time regarding anything we've talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions?
No, sir. Just want to take full responsibility.
All right. You need any more time to talk to Mr. Mulkey before we go out with the actual plea of guilty?
No, sir.
All right, then what's going to happen at this point, the prosecutor here will explain for me what he believes the facts would show if we had a trial. I want you to listen to him because now I'm going to have some questions for you about that. So, Mr. Downing.
Thank you, Your Honor. Had this matter proceed to trial, the evidence would have shown that on November 2nd, 2025, in the city of Wickliffe, Lake County, state of Ohio, Wickliffe police observed a vehicle speeding on State Route 2 eastbound. They conducted a traffic stop. The owner and driver of that vehicle was the defendant. Officer asked if there were any firearms in the car. Defendant did advise there was a firearm in the center console, which was a Ruger SR9C pistol with serial number 333-59773. The firearm was unloaded, but there was a magazine under the floor mat which was accessible to the defendant that was loaded with ammunition. There was also a box of ammunition found in the vehicle. Defendant was cooperative throughout the process, did state the firearm was his, and he was using it as an armed security guard. For purposes of the weapons under disability, the defendant has a prior felony offense of violence on his record conviction, burglary and felonious assault in Cuyahoga County Court of Common Pleas. Case number CR 08-506-030A, dated October 29th, 2008, which placed him under disability and not able to possess a firearm.
All right, Mr. Clark, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show if we had a trial?
Yes, sir.
What, if anything, do you have to say about those facts as he presented them? Are those facts true? Did you do what he said?
I did exactly what he said. I take full responsibility, Your Honor.
Very well, then, regarding count one, charging you with having weapons while under disability, a felony of the third degree, along with the forfeiture specification, what is your plea to that?
Guilty.
All right, I have in my possession here a 4-page document called a written plea of guilty and judgment entry, which sets forth everything we just talked about.
Yes, sir.
Before I can accept your plea, I need to make sure you understand the document and that you sign it here in open court. Now, my understanding is before I walked out here, you had a chance to go over that document with your lawyer. Is that correct?
I did, sir.
Mr. Mulkey, is that accurate? Did you review that with Your client answers questions.
I did, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Clark?
Yes, sir.
So you understand what the document says?
I totally understand what the doctor said.
Any questions for me about it?
No, sir.
No, it also appears you signed the document. Did you sign it?
Yes, sir.
Mr. Mulkey, did you witness that signature?
I did, Your Honor.
And you as well, Mr. Downing?
I did, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of all those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 1, having weapons while under disability, a felony of the third degree in violation of 2923.13A2, along with the forfeiture specification. Counts 2 and 3 will get dismissed at sentencing, but I'm going to continue the sentencing hearing. I'm going to order a pre-sentence report investigation. I'll continue bond, $10,000 cash surety of 10%, with an order that you don't possess any firearms. So what all that means as far as bond goes, Mr. Clark, I'm not doing it, changing your bond. Your bond's continued and you don't need to do anything else. You do need to comply with the conditions of your bond. One of those is that you don't use any drugs while you're on bond.
Yes, sir.
You have to submit urine screens if they're requested. They have to be negative. A positive screen would result in your bond being revoked and a warrant being issued. You understand that? Now, the whole purpose of this report is so that I can learn more about you before sentencing. The way the probation department gets the information they need to prepare the report is they're going to conduct an interview with you. It's important that when you meet with them that you're open and honest with them, because they're going to check and verify everything you're telling them.
Yes, sir.
If they learn you're misleading them in any way, they'll let me know that, and I would obviously consider that sentencing. You understand that?
Yes, sir.
Further, in order for them to be able to prepare and complete this report, that interview with you has to take place. So it's important you show up on time when scheduled at the probation department for that interview, because if they can't conduct the interview with you due to your missing the date or not cooperating, then they can't do the report. And without a report, the law doesn't even allow me to consider probation as an option. And I won't continue the sentencing to a future day to get the report done and the interview done because you didn't show up initially when you were supposed to. Do you understand that?
Yes, sir.
Okay. So you're going to leave here right now. You're going to go over to the probation department, fill out some initial paperwork, and then get your date to come back for the interview. So make sure you go there right from here.
I would definitely do that, sir.
All right.
Not a problem.
Mr. Mulkey, anything else for the record?
No, Your Honor, I'm going to take him over personally. Thank you,
Excellent.
Judge.
Great. Mr. Downing?
No, Your Honor, thank you.
Thank you.
629.
Both are captioned State of Ohio versus Isabella Rotundo versus 25 CR 085. Second case is 25 CR 581. We're here for a final hearing on the state's motion to terminate community control sanctions. Been previously waived probable cause. Defendant's here in court, which is with the attorney, Mr. Charles Langmack. Mr. Langmack, how would the defendant like to proceed this morning?
Thank you, Your Honor. At this time, we'd like to waive the final hearing and admit to the violation.
Thank you. Mr. Rotundo, you've been charged with violating the conditions of your community control sanctions in both of these cases. Specifically, it's alleged you violated Rule 11, Condition 3. Rule 11 requires you to comply with all special conditions set forth by the court. Condition 3 ordered that you enter and successfully complete the treatment program at either Oak House or Nevaeh Ridge and follow all aftercare recommendations. It's alleged on April 24th of this year you were unsuccessfully discharged from Nevaeh Ridge, thus you did not comply with this condition. Now, you have the right to have a final hearing regarding this allegation, which is a hearing where the State of Ohio will be required to prove the merits of what they're alleging with this violation. You can have that hearing, but you can also waive the hearing if you desire and plead guilty to the violation. Your attorney has just indicated to the court he believes it's your desire to waive the final hearing and plead guilty to the violation. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver and your plea, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If in fact that did occur, in each of these cases, the court could extend your probation up to 5 years. It was originally 2 years, starting on January 14th of this year. I can impose more restrictive sanctions against you, which could include an order that you serve time in our Lake County Jail, or I could terminate your probation and send you to prison. And if I did that, in case 25 CR 581, it could be 6 to 12 months in prison. In case 25 CR 085, it could be 6 to 12 months in prison on count 1 and count 2. Those can be consecutive to each other for up to 2 years in prison. And both cases can be consecutive to each other. So overall, there's a maximum sentence with both cases of 3 years in prison that can be imposed if you violate. You understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing in either in these cases, or do you want to waive the final hearing in both cases and plead guilty to the violations?
Plead guilty, right? Plead guilty to the violations.
Very well then, in regards to case 25 CR 085, we'll do them both at the same time, and 25 CR 581, for the violation of violating Rule 11, Condition 3 for not successfully completing the treatment program in the Bear Ridge. What is your plea to those violations in each case?
Guilty, Your Honor.
All right, the court will accept your plea of guilty, find that you did violate your community control sanctions. Mr. Lamack, any reason not to proceed with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. As was previously discussed in chambers with yourself and Probation Officer Henley, clearly Isabella has some mental health issues. I don't think anyone's questioning that or doubting that. And unfortunately, quite often they get the better of her. It's not an excuse, but unfortunately merely a fact in her life. It's been that way for a little while. She needs the help. She wants the help. But sometimes she rejects the help, as unfortunately some people with mental health issues do. As Your Honor knows, Nevaeh Ridge is not a lockdown facility. She was sent there, and despite the trouble she has had and some disagreements with the staff as far as medication issues and other things, she has never left Nevaeh. She's never walked away and said, forget it all, I'm chucking it and I'm out of here. I think that's a bit of a credit to her, because obviously this happens with some people. She at least stuck that out before she was removed. Certainly she can't force herself to stay there. What we're asking for, Your Honor, is that she remain on community control, that she be allowed to keep getting treatment, keep getting mental health help, because I think everyone agrees that's what she needs the most. That needs to be addressed constantly. She needs it now, she'll need it for a while. I obviously not a doctor, I can't tell you. 6 months she'll be fine if she does A, B, C, and D. That would be fantastic, but I don't know. But she certainly needs the help. She needs more help than just going in and taking classes or going to see somebody once a week. She needs residential treatment where she lives somewhere where there is always someone there that can help for whatever issue is going on at the moment. Certainly, she needs to be taking classes there and learning how to make better decisions and fully engaging in the treatment that is available to her. there were some stumbles with that at Nevaeh Ridge. We are asking for a separate or a different facility. It's Everett, which is a part of Signature Health. Excuse me. It is also inpatient. We think it'll help give her and continue to give her the treatment and help that she needs. We understand that their policy, or I've come to find out that their policy is you're allowed to just go to the store anytime you want and leave that facility anytime you want. I suppose for some people that is not an issue, but for Isabella, I think that might become an issue. So we ask that if you were to grant her attendance at Everett, that it be a court order, that despite their policy of allowing her to leave, so they're not going to force her to go to the store or leave the facilities, but there be a court order that she is not allowed to leave.
How's that get enforced?
Well, we're asking if a GPS could be put on her, and that way the court will know at all times where she is. And so if she were to leave that facility or the grounds, whatever that boundary might be, there'll obviously be an alert, a warning of some kind, say, hey, she's 2 blocks away, not allowed to do this. It certainly is, I mean, this court's well aware of GPS monitoring. We would ask that that be an option. So that way, if she violates the court order, certainly, you're sitting right back here. So her leaving the facility will not be a concern as far as that. As I said before, she could have left Nevaeh, although that would have ended up in a violation. This would essentially be the exact same thing. If she leaves Everett, the court will know about it immediately, sooner than if she left Nevaeh, and then obviously there's the sanctions. Her probation would be violated, and she'd be right back here facing you, Your Honor, for leaving their facilities, which I don't think will be an issue. Wasn't before. Certainly I can't guarantee anything in this world, but I think her history has shown that she's not going to leave a facility, even if there are difficulties and disagreements between her and what's going on there, whether it be the treatment, whether it be the medication she's not getting or getting, and it's not the same as she was prescribed. Whatever those issues were, she never left. Even when the Dustin Down came to visit her out there, she, as was told, she did the appropriate maneuver. She left, went into the back, did not consult her, told other people, you're not supposed to be here, and that was taken care of. So she can do the right thing. The question is, how much can she do the right thing? And I think every day, ideally, you get closer to doing everything the right way. A little bit. There may be setbacks, as there often are in mental health treatment, whether it's drug and alcohol or mental health or anything where people have challenges. You're going to fall backwards here and there or relapse on drugs. I know I've heard a million times it's a part of the recovery is the relapse. I think it's just an unfortunate reality. Not everything moves forward constantly all the time at a sustained rate. Everybody stumbles in life. If Your Honor is not willing or desirous, does not feel appropriate to go to Everett, even with the GPS monitor and the court order not to leave their facilities, we would ask that you consider Oak House. As we heard, that she probably would not be welcome back in Nevaeh Ridge, but that Oak House is a possibility if she is to go back to their program, I guess. Certainly that is an option. We would ask you, if not Everett, to consider Oak House. We feel that would also be appropriate. I mean, certainly it's not a lockdown facility as well, but once again, we're in the same situation when we're in Nevaeh. I don't think the fear is that she's going to run away or leave, because she had that option before. She's shown she wasn't going to. So I don't know. I don't think that would be an issue as well. I mean, certainly GPS is available for that if needed, but I don't think it would need to, because she's not allowed to leave Oak House as Everett. I think the fear with the CDCF in Lorraine Medina, which I believe is in Medina County, is that, and I'll admit I'm not as familiar, well, I'm not familiar at all with that facility. I've never had anyone considered for that one. Certainly we understand the reason she can't go to the equal facility in Lake County, which would be the NeoCap facility, because she used to work there. So that would be some sort of a conflict that would not make that available. The concern is that she would not be medically able to participate because of her obvious there were medical issues.
Who's expressed that concern aside from your client? Because she's relying on her knowledge from when she worked there. She hasn't been assessed by anybody at any of these facilities. They haven't said that. This is your client saying because of her experience when she worked there that she wouldn't be able to do what they require her to do.
And I'll be honest. I don't know anything about this facility down in Medina.
I guess I shouldn't make statements in regards to what my concern is regarding that because
and
I don't have anything in front of me saying that that's an issue. I have Miss Rotundo saying she can't do it because of that.
Right, and I've heard nothing from the I guess, I don't know if NeoCap would have done an assessment sort of similar to what this place down in Medina would do if they're kind of on equal levels. That to say, oh yeah, she'd be great here, she'd be great there, or she's not going to work here, she's not going to work there. I don't know if an assessment was ever done by NeoCap as far as that goes. Or, because normally that's the case in these situations where NeoCap will talk to them and say, yeah, you'd be a great fit here, or no, we can't do it for reason A or reason B. And I don't know, I haven't heard, and I don't know.
That's my point. You're saying this is a concern, and why is that the concern? That's your client's concern.
Well, she was never assessed by them.
I understand.
To say yay or nay.
I understand, but you're making a statement that's fact. That this is the issue.
No, what I was saying was that was her concern. Was that? I mean, I prefaced the entire thing by saying I haven't talked with them. I don't know anything about this facility. It's a brand new.
I understand. That was my point.
Yeah, and I apologize if I misstated somehow. I'm not telling you they definitely will not, or this will be the outcome, because I don't know. But that's a concern she has just with her familiarity with the Lake County NeoCap. That's all I'm trying to impress upon you.
I'm familiar with her concerns.
Yes. So that's, and I guess, because currently she's in a lockdown, it's a mental health lockdown. She's 23 hours a day, she's locked down, and she gets an hour out. I guess the concern is, will there be such a, the same thing, I don't think you can do that in a treatment facility. You can't be locked down for this because you've got to participate in obviously many different activities. So that's sort of a concern that we have. But once again, I have nothing from this other facility to say, yeah, I don't know, we'll be fine with that, we're all good, we can accommodate anything. I don't know. I mean, I don't know how they do that, and if Your Honor says this is where she's going, they have no choice. Once again, it's sort of an unusual scenario for me, in that this is the first time I've ever encountered this facility and possible orders for her to attend there. I don't know if they can refuse her. I'm unfamiliar with how they operate down there. So that's essentially what we're asking, Your Honor. We want her to stay on community control. She needs the help. I mean, she definitely needs the help. There's no question there. Nobody's going to tell you.
No, I've offered it twice so far, and she's violated twice. Now you're asking me for a third time. She's had 2 violations now, in just a matter of months, and it hasn't been that long.
Understandable, and we're merely asking for another chance at treatment. Obviously, prison is always the option. Prison doesn't go away even if you give her a 3rd or 4th or 5th chance. It's always an option, so it doesn't disappear. The more chances you get, the less prison you're going to get. Certainly, if she goes to Everett or to Oak House,
no, we just waste more and more resources and people's time and effort, where other people that would take advantage of it.
I get it, and that's a point of view that certainly does make some sense, but I think it's also important not to, and I'm not saying you're denying her or giving up on her, but I think to give her another chance is not, it's not a negative, it's not a failing of the court or the system or her options to give her another chance. I think people need chances. I mean, I'm not saying 2 strikes, this is the 3rd year out, or 4th year out, or 2nd year out, or first time. But what I'm saying is, she deserves the help just as much as I would in her situation, or anyone else would, whether she works fantastically well and is really killing it in therapy, or she's having a lot of issues. I might argue that somebody having a lot of issues in there might need it more.
You say someone deserves the help if they've been given shots 3 prior times, they deserve it just as much as someone that's never been given a shot before?
I'm saying everybody deserves the help. Now, it's not for me to say, certainly in this situation it isn't for you to say, but that someone shouldn't get that help. I mean, I don't think Your Honor says she shouldn't get help. That wouldn't be the order, no matter what happens.
You just made a comment that she deserves help just as much as I deserve help. And I said, and I don't know if I agreed that someone that's been given opportunities for help before and is violated twice in just a matter of months is deserving of help as much as someone that's never been given a shot before and they're in front of me and never had that chance before.
Well,
that's all I'm saying.
I got you. Well, my statement is that I think everybody deserves help, whether you've screwed up in the past or not.
Doesn't matter how they do. They come back their 12th time. They deserve the help. Deserve.
Well, I suppose at some point
they maybe need it, but they deserve it. I don't know.
I suppose if somebody says, I don't need it, I'm fine, but you're not fine, or forget you, I'm not gonna, I don't want the help. I don't care what you do. You can send me back, but I'm just not gonna do a darn thing. That becomes an issue. But I think everyone does deserve the help and should be given the opportunity, as she has, and this is second violation. Yeah, obviously that's an issue. I'm not saying forget it, don't even concern yourself with the violations before. But what I'm saying is, she needs the help.
No, it's different from deserves. I agree, she needs the help. The question is, what she deserves it and we're wasting her time.
My argument, Your Honor, is that I believe that she can successfully take advantage of the treatment, of the help. There have been issues. And once again, nobody goes to Nevaeh Ridge for a quick 2-week getaway from home as a vacation. The reason that people are there is to get help. She needs the help, and she needs to make sure that she does everything she can to not only allow herself to get the help, but, as we've heard, allow other people around her to get the help. She needs to work with them for herself and not impede her own recovery as well as everyone else's. And I believe she can do that with the proper medication, with the right attitude. Sometimes that attitude is less than perfect. Sometimes my attitude is less than perfect. I think we all have challenges in different ways and different times. She's got more specific. We're asking, Your Honor, that you consider keeping her here, either at Everett or at Oak House, Your Honor. And if it's an issue, the GPS, I know that's unusual, but like I've said, I've never had anyone go to Everett before. I was unaware that they could just let you walk away. And obviously with a court order, that sort of takes that option off the table. As much as basically equates it to Nevaeh Ridge as far as being able to walk away. So that's what we're asking for, Your Honor.
Thank you.
Right.
Mr. Rotundo, you have the right to address the court before sentencing and say anything you'd like me to know. Is there anything you want to say at this time?
There was something I'd like to read to you that I wrote. Dear Honorable Judge Culotta, I want to first and foremost thank you for the opportunity that I was given at Nevaeh Ridge. I loved the treatment material, the accountability, and the privilege to build a relationship back with my children. I consistently tried my best to be non-reactive and to think before any decision I made, but consistently continued to struggle with my mental health. One night at Nevaeh Ridge, when I took a fall with my walker, I went to the hospital and they held me on a psychiatric hold and said I needed help. I saw a psychiatrist for 10 years as a child and somewhat managed my issues up until my father passed away and my tumultuous life began. I sincerely ask you for the chance to face the root of my problems head on and address all of my trauma, grief, and mental health issues. I want to be a woman that my family, the courts, and everyone else can be genuinely proud of. I would like a chance to give hard work and determination to result in a successful, positive change in my life. And I do apologize.
Thank you. Mr. Mack, anything else you'd like the court to consider?
Nothing else, Your Honor. Excuse me.
This court has considered the pre-sentence report investigation that was previously completed, as well as the drug and alcohol evaluation. Considered the facts and circumstances of the underlying offenses in each of these cases, the nature of the offenses in the cases. I've considered what's been said here in court today. I've received some letters in support of the defendant. I've read and considered those. I have considered the defendant's performance on both intervention in lieu of conviction, which she was given the benefit of initially in this matter, both of these cases, as well as performance on probation. All of this has been considered by the court and the purposes and principles of felony sentencing set forth in 29 and 2911. As for the factors in 29 and 2912, in both cases I'm going to incorporate the findings I made at the original sentencing hearing with the additional finding today that the defendant has failed to comply with the previously imposed sanctions ordered by this court, which is a factor that indicates recidivism is more likely. In making the decision as to whether, first of all, probation should be continued, I need to determine whether the defendant's amenable to community control sanctions, meaning not whether she needs it. There's no question she needs the help. But being amenable to that is a different story. Being amenable means she's willing to follow the rules, comply with the conditions of the court, comply with the conditions of a treatment center, if that's where she was to go to, do what she's supposed to do, follow the rules. She's demonstrated that's not the case. Mr. Tundo's going to do what she wants to do, and if it doesn't go her way, she's going to throw a temper tantrum. She's going to try to dictate how things are going to be done. She's going to be disruptive. They had to cancel, 3 or 4 group meetings because they can't have a meeting because if you're being disruptive during these meetings, they can't have group sessions. So not only are you not getting what you're supposed to get done, but other people at the facility there aren't able to get the treatment they need because of your temper tantrum that you have to throw during these hearings or during your group sessions. You're under the impression that you're in charge. And you're going to dictate how things are going to happen, what you're going to do, how it's going to be done, what people are going to do for you. And that's not the way this works. But that's the way you expect it to work. And then that's why I'm having difficulty here, because I can't see that changing. So yeah, do you need help? You need help. I don't have any disagreement with your lawyer on that. Are you deserving of the help? I have maybe have this issue on that, because you've been given help twice here. And you violated twice already.
Can I please just have the opportunity to show you that I can do this, along with my probation officer, Cindy Henley, and Mr. Craig Berry.
Well, we've done that already. We've done that twice.
He told me one day he wanted to hear my lead and that I can do this. And it's the first time I felt like somebody's believed in me in a long time. And I would like to show you personally that I can do it. Mr. Culotta, I am sorry, and I mean that. I do not think it should just go my way. I'm just struggling really hard, and I just want help. And I would love one day to be able to walk into this courtroom on good terms and look at you and smile and say, I did this.
I would love that. I really would love that. I genuinely would love that. I don't see that.
And I can't do that. I can't.
I'm just having a difficult time seeing your attitude changing in terms of doing what you're asked to do if it's something that you disagree with. That's going to happen. That's going to happen in life. But when you're on probation, you got to follow the rules, and you're going to think that there's petty shit going on, and it's not stupid, it's not necessary. But you got to do it. Instead of standing up and voicing your displeasure with it and disagreeing and denying things, you got to do it. And you can't do that.
I can. I promise you. I can sit down and shut up, and that's what I need to do, because obviously I don't know it all. I don't know a lot, and I have a lot to learn. And when I say I want to be a woman that not just my family's proud of, but society and the courts, and I would love one day for Mr. Berry and Miss Henley to be like, I'm proud of you, you did this, and you as well. And I can do that. I really can.
Well, they would want that. That's why they have that job. They enjoy that. It doesn't happen that often, but they appreciate that. I appreciate that. It's just people saying that's what they want and they're going to do. Actions speak a lot louder than words.
Yes.
Actions speak a lot louder than words. If I go along with continuing on probation, it'll be the third time now I've given you this chance, and you've been in front of me saying you can do this, you want to do this, you need to do this. These words are the same I'm hearing that I heard before.
That's why I'm asking for help, especially with my mental health and my grief and everything like that. And when I first got to Nevaeh, I kept asking about grief counseling because I know that would help me a lot. I had never even been in trouble before my dad had passed away, and it's not an excuse. It's just something that was really traumatic. I watched my father die. I was there while he passed away, and it's something that's really taken a toll on me mentally. And it's something I need to deal with that I've been avoiding for so long. And I think if I just get to the root of all of it, I could change, and I could show you that I could do it. I really can.
Well, I will find that you're amenable to community control sanctions and give you one last chance and not send you to prison at this point. I'll continue on community control sanctions. I'm going to order in both cases, well, let's strike that. I'm going to order that in case 25 CR 085, that you serve 65 days in jail. You have credit for 18 on this probation violation. I'm going to further order that upon a bed becoming available at Oak House, that you be released from the Lake County Jail. This is for both cases, the second portion. You released from the Lake County Jail, you enter and successfully complete the treatment program at Oak House. Any balance of the 65 days will be vacated. So there's just enough time, more than enough time to get you to the center. You're to enter Oak House, successfully complete that program, and follow all their aftercare recommendations. You're going to be on a short leash at Oak House. You're not going to play around. I'm going to tell them not to play around. There's no reason they need to put up with it. If you're going to go there and argue with them, disagree with them on stuff, be demanding, you want things to be this way, you're not going to do this, I'm going to tell them that they need to discharge you at that point. You're not going to be getting behavior contracts or whatever they call them, second chances. You're going to put your money where your mouth is, because right now you said you're going to show you can do it, and you're going to be able you want to show us that you can do it. You're going to get the chance to do it.
Thank you, Your Honor.
Well, thank me by doing it. I'd be happy to see you after the end of this, and not before that. And you have been successful. You may not believe that, but that's true. My words I'm expressing here are just based on the history that we've had so far, and I have doubts about that. But I'd love to be proven wrong. But you're going to have to be able to just shut your mouth and do what they tell you to do.
Yes, Your Honor.
Further conditions are going to be the same as they were before. You're not to use any drugs or alcohol. You must submit random screens. They have to be negative. You're to continue participating in medically assisted treatment by continuing with monthly Sublocade injections. That's going to be the nature of the medically assisted treatment. You're to attend 3 AA meetings a week and have a sponsor. I think I said random urine screens. Would submit random urine screens. Again, they have to be negative. Once you get out, you're to obtain and maintain full-time employment or school education training. If you want to get some type of degree or certificate, you can do that. But on a full-time basis, you're keeping yourself busy working, going to school, or some combination of the two. You'd have one doctor, one dentist, one pharmacy, sign whatever releases are necessary for probation to be able to speak with doctors or counselors to obtain grief counseling. You'd have no contact with Dustin Doan unless ordered by domestic or juvenile, unless permitted by domestic or juvenile court order. Pay court costs and supervision fees. You're to take medications as prescribed. So aside from I'm specifically talking, what I mentioned before, the Sublocade is the medically assisted treatment. What other medications are prescribed? I don't know if it's through Signature Health or through Lake Jog, whatever you want to do in that regard is fine, but you're to take them as prescribed by whoever's prescribing to you. Resolve whatever outstanding warrants there are. Is there still warrants that are outstanding? I imagine there are. Get those resolved as soon as possible once you get out. Ms. Henley, is there anything else that we should be considering here?
No, Your Honor.
Ms. Rotundo, you understand all the conditions of your continued community control sanctions?
Yes, Your Honor.
Any questions for me?
No, just thank you.
Well, I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, another motion to terminate your community control sanctions will be filed. If it's found after a hearing that you violated, I could technically extend you up to 5 years. I can impose more restrictive sanctions against you, including local jail time, or I can and will terminate your community control and send you to prison. And if I did that, in case 25 CR 085, it would be 12 months on counts 1 and 2 consecutive to each other. And in case 25 CR 581, it would be 12 months in prison. That'd be consecutive to the prison term in 25 CR 085. So for both cases together, it's 3 years in prison. All right, Mr. Lamack, anything else for the record?
I just had a question. I'll be going on. You said no contact with Dustin Dowen unless,
Well, I mean, if there's a court order that if she has to go to court and he's there, she's obviously going to have contact. If there's some court order regarding, visitation and they need to be able to meet to
Okay.
do something in that regard, then it's permitted.
okay, unless required somehow in those, okay. No further questions.
Yeah, and if there's a court order that permits them to have contact for some purpose,
I understand.
they're allowed to. I'm not going to trump any other court order in that regard, but that's what I mean by that. All right, thank you. We are present in case 25 CR 053, State of Ohio versus Regis Kidd Jr. And it was previously placed on community control sanctions of this court back on April 1st of last year. The motion to terminate those community control sanctions has been filed by the state. Defendant previously waived probable cause. And we're here for a final hearing on this violation. Defendant is in court with counsel Mr. William Watson. Mr. Watson, what's the defendant's intention at this time regarding these violations?
Thank you, Your Honor. May it please the court, I've discussed this matter with my client. He is prepared this morning to waive his final hearing, plead guilty to the violations, and respectfully request to proceed straight to sentencing, Your Honor.
Thank you. Mr. Kidd, you've been charged with violating the conditions of your community control sanctions. Specifically, it's alleged that you violated Rule 8 on multiple occasions. Rule 8 prohibits you from using, possessing, or having under control any controlled substance not prescribed to you by a licensed physician. And the first violation alleges that you submitted urine screens on March 24th, March 31st, and March 31st to Cuyahoga County Adult Probation that tested positive for marijuana. The second violation is that you submitted urine screens on April 17th that also tested positive for marijuana. Now you have the right to have a final hearing regarding these allegations, which is a hearing where the state would be required to prove the merits of what they're alleging. You can have this hearing, but you can also waive the hearing if you desire and plead guilty to the violations, and your attorney has indicated he believes that's what you want to do, waive the hearings and plead guilty. Is that correct?
Yes, Your Honor.
I'm sorry?
Yes, yes.
Well, before I can accept your waiver, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If, in fact, that were to occur, the court could extend your probation up to 5 years. It can impose more restrictive sanctions against you, including an order that you serve more time in jail, or I could terminate your probation and send you to prison. And if I sent you to prison, it could be 9, 12, 18, 24, 30, or 36 months in prison, which could also be, that's what it could be if I did it today. You understand all the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive that hearing and plead guilty to the violation?
I want to waive and plead guilty.
Very well. As the first violation for testing positive on the 24th and 31st of March, what is your plea to that?
Guilty.
As for the second violation for having again tested positive on April 17th, what is your plea to that?
Guilty.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court, extremely brief. I know the court, when he was here for sentencing, gave him a chance on probation, gave certain rules and restrictions, yet he had another case in Cuyahoga County. Ultimately, he was sent to Harbor Lights there for treatment. Apparently, testing positive for marijuana there. I've spoken to Mr. Kidd. I mean, he's told me he's working on himself. He's still a young kid, Your Honor. No pun intended, I know it's his name. But he's still young, and he's told me he is trying. I know this court usually doesn't take kindly to people that violate probation, but with respect to this court, I guess he's never really done anything direct with this probation department. I'm gonna ask the court to consider respectfully giving him one more chance at probation, whether the court wants to just continue him on probation. Now, I just spoke to Mr. Kidd. He had indicated he would love to go back to Harbor Lights. I don't know if the court would.
Sure, he's smoking weed. He's having a party there.
Well, Your Honor, I know that happened there, but the reason he had requested that to me was only because he'd be closer to family if need be. That being said, Your Honor, he also told, and I did tell him, I said, well, the court is considering, not that he's going, but the court is considering possibly sending him to, NeoCap, and he flat out told me, well, I would welcome that too. He goes, the only reason being is he knows it's far away and he's not close to his family. But that being said, Your Honor, he's not dictating anything at all. He wants another chance at probation, and B, he's willing to do whatever it takes, whatever the court feels is necessary. So I think those are positive signs, Your Honor. I'm asking the court to just consider the fact that he is taking full responsibility for his actions, and he does want to continue treatment. Thank you, Your Honor.
Thank you. Well, Mr. Kidd, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I want to say, I know it looks bad that I violated. I have been trying. I'm getting my GED as you asked me to get. I've been going to school. Harbor Lights was helping me get my GED going through Seeds of Literacy. I was almost finished with all my classes. I'm doing the diet program. I was almost finished with all those. Like, I'm actually trying. I end up smoking the marijuana because one of my brothers got hurt, like fatally hurt, and that's why I smoked the marijuana. I know it was wrong.
Why did that make you smoke marijuana?
I didn't hear you.
Why did that make you smoke marijuana?
Because my brother passed away, and I was going through things, and there was a lot on my head. So I chose to do that, which I know is wrong. I chose to do that to get it off my head. It was a lot on my head. And I apologize for that, but I just wanted you to know, like, I wasn't just like specifically trying to do just anything and be reckless or anything. I was just going through stuff. So I chose to do that.
We all go through stuff. You're going to be going through stuff your whole life.
And
when you were here last time, you smoked marijuana when you were on bond, and then at the time of the sentencing, you said, and I wrote this down, it's for marijuana, defendant claims, quote, I can stop whenever I want. It won't be an issue. It won't be hard not to use marijuana if I get probation. I will never do this again.
And that's where my head was, and that's what I was going in to do. That's what I was trying to do. I didn't just think like, okay, let me just smoke weed and just disregard everything. That's not what was on my head. I was just going through, like I said, my brother passed, so I was going through stuff, and it's not an excuse for smoking the marijuana.
Oh, yeah, it is. That's what you're using it for.
I'm not trying. I'm just telling you what my head was at the time. Like, that's what my head. I wasn't just disregarding everything I said. Or
You're in a treatment center when you did it. It wasn't even that you had a chance to be out on your own.
I understand. I was just, like I said, it was a lot on my head, and I wasn't in the right place in my head at the time. But like I said, I'm trying. I'm not just trying to be ruthless or anything. I'm trying, and I'm willing to, if you send me the NeoCap, I'm willing to do it and go through with the program and everything. I was just asking, like, if I can go back to Harbor Lights, because, like, they are helping me with a lot of different things, not just like being sober and not smoking or drinking or anything, but like they helping me with like my GED and stuff. They helping me, like I'm doing Thinking for a Change. I finished that, stuff like that. Like they helping me with a lot of different things, housing and stuff like that. Giving me a job and stuff. That's why I asked him if he could send me back to Harbor Lights.
Is there anything else you'd like to say?
No, Your Honor.
Mr. Watson, anything else?
Nothing further, Your Honor.
Court has reviewed the original pre-sentence report and investigation. I consider the facts and circumstances of the offense involved, the nature of the offense involved. Consider the defendant's performance on probation. Really hasn't been on probation in Lake County. I mean, he gets credit for it all, but he hasn't done anything out here because of Cuyahoga County. Nature of the violations involved. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. So the factors in 29-29-12, I'll incorporate all the findings I made throughout the case regarding the factors. At this point, court finds that prison will be consistent with the purposes and principles of sentencing. But I will find, Mr. Kidd, that you are still amenable to an available community control sanction and give you one other chance here. But I'm not going to just push you off into Cuyahoga County and their probation like you did for the last year. I'm going to extend your community control sanctions by 6 months. I'm going to order that he's at 149?
Correct.
What's the weight for
Current weight, I'm not 100% sure.
I'll just order 210 days in jail, but you won't be there nearly that long, but 210 days in jail. You have credit for 149. Well, how much is on the probation violation? We'll do it that way. That's what I meant to do.
25.
All right. I'm going to order 85 days in jail. You have credit for 25. As soon as a bed's available at NeoCap, however, you're to be released, and it won't be that long. You're to enter NeoCap, follow all their aftercare recommendations. I'll order at this point that you, upon completion of NeoCap, that you participate in the transitional day reporting program for 30 days. You probably won't have to do that. It's a 30-day period in jail after NeoCap that helps you make the transition from being locked up to being on your own. Some people have nowhere to go. They have no housing set up, no work set up. If you're set up with a place to live and things are in order, I'll vacate that. And that's something you can make sure is in place when you get out of NeoCap. But some people don't have that. And I put it in place for everybody then, just in case, because I don't know. The other conditions are then going to be the same as they were. Not to use any drugs or alcohol. That includes no marijuana. AA meetings pursuant to any recommendations from NeoCap. Verifiable employment and education or education, full-time. Obtain your GED or make a reasonable effort at obtaining your GED, as well as your driver's license. You're not to possess any firearms. Pay your court costs and supervision fees. Derek, anything else I should be thinking about or considering?
No, Your Honor, thank you.
So, Mr. Kidd, you understand all the conditions of your continued probation?
Yes.
Any questions for me?
How long would I have to be in NeoCap?
It depends. That's up to them to determine how long they believe the treatment you need. It's not a set number of days. It depends on the individual.
It's 3 to 6 months.
It's somewhere usually about 3 or 4 months, but could be more if there's mental health issues. I don't know if that's an issue here. It doesn't believe that there is, so somewhere in that range. But I don't order a specific amount of time because it depends on their treatment plan for the individual. Any other questions?
No. How would I be able to get back to Cleveland from? That's why I was asking.
Well, my office will help you with that. I'll give you a number.
Okay. All right, that's it.
I need to advise you if you fail to comply with any of those conditions, any of the rules of probation, if you leave Ohio without permission from the court, if you commit another crime while on probation, another motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 36 months in prison, consecutive to any other sentence you may be serving for something else or that you're being sentenced to at that time. You understand that?
Yes, Your Honor.
All right. Anything else for the record, Mr. Watson?
Nothing further, Your Honor.
We are here on the matter of the State of Ohio versus Christian Frierson, case number 26-CR-000-075. The defendant is present in open court with their attorney, Chad Mulkey. We are set today for a sentencing hearing. The defendant previously pled to a lesser included offense of count 2, attempted grand theft, a felony of the 5th degree. Since then, a pre-sentence report was ordered and has since been completed. The defendant has 4 days of jail time credit.
Mr. Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor, and however the court wants to handle this procedurally, I do believe that his mother, Yvette Walters, is present with us here in the courtroom and would also like to address the court.
You can hear from her whenever you'd like her to be.
I'd like her to go first.
Okay, that's fine then. Whoever it is that would like to address the court, you can stand right where it is that you're seated. Spell your last name for the court reporter, please, and say whatever you'd like me to know.
Hello, Your Honor.
Good afternoon.
My last name is Walters, Walters.
Okay, take your time and say whatever you'd like me to know.
What's your first name? Yvette, Yvette. Stepping the podium, so I apologize. But, Your Honor, thank you for allowing me to speak today. I stand before you as a mother who has watched her son struggle, fall, and now work with determination to rise again. Christian was raised in a 2-parent household for many years, but during that time he was exposed to some of the trauma I experienced before I made the decision to divorce my husband, my ex-husband. I have now seen those early experiences have left lasting marks on both Christian and his older brother. Even with the stability I worked hard to create afterward, the emotional impact followed him into his adulthood. Christian later served in the United States Navy, hoping that service would give him a fresh start and distance him from the pain he carried. But when he returned home, he was still holding on to wounds he didn't know how to address. Instead of seeking help, he tried to push through alone, and that led him down a dark path of poor decisions and untreated PTSD. The young man here before you today is not the same young man who committed these offenses. He has begun counseling to address his PTSD and the trauma he avoided for years. He has been working steadily, and he has remained focused, responsible, and determined to stay productive. Christian is also preparing to welcome a son on September the 19th, my first grandson. That reality has changed him in ways that I've never seen before. His priorities are different. His mindset is different. He wants to be present, stable, and a responsible father. He wants to break generational cycles, not repeat them. He has even begun working on a small business endeavor so he can stay productive, contribute positively to society, and pay restitution to the victims more quickly. He understands the harm he caused, and he is committed to making amends, not just with words, but with consistent action. Your Honor, I raised Christian and his brother alone after my divorce, working long hours while pursuing my doctorate degree to keep our family afloat. I taught them strength, responsibility, and resilience. Christian has disappointed me, yes, but I also know the heart he has. I know the man he is capable of becoming. I see him doing work step by step to get there. I'm not asking for leniency. I'm asking for a chance, a structured opportunity for Christian to continue the treatment he has started, to stay accountable, to work, to support his child, and rebuild his life with purpose. I believe in justice, but I also believe in restoration. I believe in consequences, but I also believe in the possibility of change. Thank you, Your Honor, for allowing me to speak today.
Thank you. Hang on one second, Mr. Murphy.
Oh, very good, Judge.
All right, Mr. Milky. Anything you'd like to say on behalf of your client?
Yes, Your Honor. That is those are eloquent words spoken by his mother, making my job even a little bit more difficult. But maybe I should have gone first. But in any event, Your Honor, my client is 29 years old. He does have a valid driver's license and is gainfully employed at two different employments. One is called Elite Mass Marketing Group, and the other one, when he first told me, I had to inquire a little bit further, but he works at a company called Ammo Tech, and my first thought was, do they make bullets there? I don't know that you can be around firearms with a charge like this, but no, it is a hiring agency, Your Honor.
It says Ammo Tech?
Ammo Tech.
It says Buying Tech on this.
What is it called?
Ammo Tech, Your Honor. Buying Tech is one of the companies that they're contracted with in Macedonia.
You must have listed Buying Tech on the PSR form as where you're employed.
Yeah, Buying Tech is where, Ammo Tech is basically like a staffing agency. So, Your Honor, so I will actually drive out to Buying Tech to work, but Ammo Tech is the staffing agency that put me together with Buying Tech, Your Honor.
Okay.
So, yes, Judge. And he does have a valid driver's license, which he puts to good use, and putting his time to constructive use and gainful employment. As his mother said, he does have a child on the way in September. I think that will change his future perspective when it comes to decision time to decide whether or not to commit theft type offenses, Your Honor. So moving forward, I think he'd like to put that life and those circumstances behind him, focus on his career, focus on his expecting child in September. He did serve in the military. He discharged with honorable conditions. He served, was discharged in 2017. He doesn't really have a juvenile record, except for I saw in a shared clear distance traffic event in his juvenile record, but nothing else in his juvenile record. There's no getting around the fact that he has his adult record and his pending cases, but again, he would like to resolve those pending matters. He is aware of his court dates and that he needs to handle those cases. And he'd like to be able to take care of those things as well. He would be living with his mother at 1839 Capella Drive in Euclid, Ohio. He has maintained his communication with my office, and he's been a very pleasant client to represent, very cooperative, very communicative about his case. So I would ask the court to take all of those factors into consideration. We would be asking the court for community control. I know the court does have concerns about his pending cases and the notion of new charges, but for our purposes for this case, he would ask for a chance at community control from this court. He was on probation in Cuyahoga Court as well, so he's familiar with probation rules, and he would like to just resolve all of this. And this has been a bad period in his life, and hopefully an isolated series of events within a short period of time, and he wants to move forward, Your Honor. Thank you.
Thank you. Mr. Frierson, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say?
Yes, thank you, Your Honor. Thank you for giving me the chance to speak, Your Honor. I want to begin by addressing the victims directly. I'm truly deeply sorry for the harm, stress, and disruption my actions have caused the victims. They did nothing to deserve what happened, and I know I violated the victims' sense of safety and trust, Your Honor. I take full responsibility for that. I think about it every day, and I can't undo the damage, but I am committed to making full restitution and proving myself through actions and not just my words. I understand the seriousness of what I did and the impact it had on everybody's lives. And they were affected by my choices and mine alone, and I won't forget that, Your Honor. The person who committed these offenses is not the man that I want to be. I once served proudly in the United States Navy in Japan, and after swearing an oath to protect and serve this country, somewhere along the way I lost that version of myself, Your Honor. Instead of facing the trauma and pain that I had been carrying since childhood, I turned to alcohol and poor decision to numb everything, and that dark period of my life led me to the choices I will regret for the rest of my life. I'm not offering this as an excuse, but I'm sharing it because I am finally taking steps to confront the real issues behind my behavior. I have begun counseling to address PTSD and the trauma I avoided for too long. I'm committed to continuing treatment, Your Honor, and doing the hard work to change the patterns that brought me here. I've also been working steadily, and I stay focused to be responsible. I want to work, Your Honor. I want to contribute, and I want to rebuild. I'm also preparing to become a father. My son, first child is due September 19th, and that reality has changed me in ways that I didn't expect, and I want to be present for him, Your Honor. I want to be a stable, responsible father, and I want him to grow up knowing a man who contributes to his community and not one who harms his community. To stay productive, I've been working on creating a small business endeavor, something positive, something that allows me to contribute to society and also pay restitution faster. I want to make things right, and I want to move forward with purpose, Your Honor. One of the hardest parts of all this is knowing how much I let my mother down. She raised me and my brother alone after leaving a difficult marriage, all while earning multiple degrees and working long hours. She showed me what discipline and perseverance look like, and I feel like I failed her, and that shame has become one of the strongest motivations for me to change. I want to make her proud again. And Your Honor, I understand how serious the charge is. I'm not asking for pity or leniency. I'm asking for a chance and a structured opportunity to continue treatment, to stay accountable, to work, to support my child, and to rebuild my life the right way. And I want the opportunity to prove that I can be better and not just say it. I appreciate you listening to me today, Your Honor.
Thank you. Mr. Mulkey, anything else you'd like to add
No, Your Honor, thank you.
for the state of Ohio?
Thank you, Your Honor. The state's recommending that the defendant serve a prison term. The defendant does have multiple prior felonies. Back in 2017, he had improper handling, which he received the opportunity to do diversion for. That diversion program was terminated, and on that case, he received 2 probation violations. In 2019, he has a felony of the 3rd degree abduction, a misdemeanor of the 1st degree domestic violence, endangering children, misdemeanor of the 1st degree, misdemeanor of the 1st degree criminal damaging, and 2 probation violations on that case. In 2024, the defendant had an attempted weapons under disability, a felony of the 4th degree, and in addition to all that, Your Honor, the defendant was on probation at the time of the offense. It would appear to the state that the defendant has not previously responded favorably to prior community control sanctions, so the state would recommend a prison term. And regarding restitution, the state has not received documentation from Handy Runs.
Thank you. This court has reviewed the pre-sentence report investigation. I've considered the facts and circumstances of the offense involved, the nature of the offense, the defendant's history. I've considered what's been said here in open court by the defendant, his lawyer, his mother, the prosecutor. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-2911. So the factors in 29-12. Court notes the defendant acted as a part of organized criminal activity. Nothing makes it less serious. As for recidivism factors, many of these factors are present. The defendant committed this offense while he was on probation for a felony in Cuyahoga County. He's got a criminal history of multiple felonies in the past. Whenever he's been on probation, and he's been on probation before and been given that chance at probation before, and he's violated his probation multiple times every time he's been on probation, which include picking up new felonies while he's on probation, just like he did this time. Previously, he was on probation at Cuyahoga and picked up the 2nd felony while he was on probation. This case, he was on probation for a felony charge and committed this. He's not responded favorably to previously imposed sanctions. As I indicated before, he's been given opportunities on probation for felony convictions, and he commits more felonies while he's on probation. In addition, the defendant after he was arrested on this case has been arrested on 3 additional charges throughout the state of Ohio for doing the same exact thing with the same victim. And one of those cases has already resulted in a conviction. In Cleveland, he was convicted for doing the same thing after he was arrested in this case and while he was on bond in this case in the Willoughby Municipal Court. He was on bond in the Willoughby Municipal Court until July. He was arrested in Hamilton County for doing the same thing on May 2nd. He was arrested in Cleveland for doing the same thing on May 14th. He was arrested in Jefferson County for doing the same thing on May 20th. Our case, he's arrested on April 23rd. So you get arrested in our case for doing this, you post bond, and you go out and continue the same conduct throughout the state. Your conduct is intentionally, deliberately acting to deceive other people. It's planned out, well thought out. It's not just some spur of the moment action that you decided to engage in. You didn't do it because you were in desperate need of money for a drug addiction like most of the people that we have walk through this store. You did it to rip people off while you were on probation. Those are all factors indicating recidivism is more likely. Nothing makes it less likely. Under 2913B1, court finds you committed the offense again while on community control sanction, which is a factor that overrides the presumption for community control. Prison's consistent with the purposes and principles of sentencing. And the nature of the conduct and the nature of your conduct following your arrest in this case and while on bond in this case dictates a prison term ought to be imposed. You're not amenable to community control sanctions as demonstrated from your past conduct while on probation. Therefore, it will be the sentence to this court that you serve a term in prison of 10 months. You will be given credit for 4 days you've already served. That is on count 2. Excuse me, that's in the lesser included offense of count 2. Counts 1 and 3 will be dismissed. I need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. And the defendant's ordered to pay all costs incurred in this action. Mr. Mulkey, anything else for the record?
No, Your Honor.
Mr. Knopf.
No, Your Honor, thank you.
Before the court on March the 30th, we entered a plea of guilty to one count of improper handling of a firearm in a motor vehicle, felony of the 5th degree, and one count of misdemeanor 1 OBI. The court ordered a pre-sentence investigation report along with a drug and alcohol evaluation. Those having been accomplished, we're here today for sentencing.
Mr. Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Please, Your Honor, thank you. Your Honor, he is 35 years old. He is single. He does have 2 children. He represents to me that they do have issues with autism. This is the 23 days that he's been in jail has been one of the longest, if not the longest period he's been apart from his children. We'd be asking the court for community control so he can get back to his children. He shares custody with their mother part-time currently. When he gets them, I guess, they're with his mother. Those are a concern of his to get back to. He is gainfully employed at Home Genius Exteriors, where he works full-time, and he's one of the top-performing salespersons at his job, so he's really excited about his work. He is anxious to get back. That job is still available to him as soon as tomorrow. He has no juvenile record, other than these charges in this matter. He has no adult record. He indicates that the day in question when this happened, back in October of last year, it was a horrible decision on his part to get drunk and then have that weapon in the vehicle, unfortunately. And had he not been drunk, otherwise he wouldn't have been charged. So, and then that brings us to the issue of his positive tests for marijuana. So where the court cut him some slack when he went for his PSR referral and then tested again. I've certainly admonished him about the use of marijuana, and certainly as a probation condition that he's not to be smoking marijuana or being around it, or in any situation where he could inadvertently somehow get it into his system. He will take that very seriously, Your Honor.
Why do you say that? He didn't take it serious when he left here last time.
Well, yeah, and that was before he did his 23 days in jail, so I believe that has demonstrated to him that even marijuana, is enough to trigger a community control violation, and certainly he felt the sting of that with his bond getting revoked for that. So that's why I would say that. Your Honor, certainly you can inquire of him any questions you have about that or any other issues, Judge. But again, we would be asking for community control. I know there's some discussion about a jail treatment program. He would like the opportunity to get any recommended treatment done on the outside as a condition of probation. But I did explain to him that the jail treatment program may certainly be a possibility for him. Thank you.
Thank you. Mr. Battles, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
I just want to apologize, just not just alone for my actions, but just taking time out of you guys' day to have to deal with my decisions that I made. I understand, and I hold myself fully accountable for what I've done. I just ask that if I can please just have probation, get back to my kids. I would never, ever step foot in this court for anything, for any infraction, for any probation violation. I've been with my kids since the day that they were born. Even when me and my child's mother split up, we still have shared custody. We never had any court issues where custody battles, anything like that. The only lie I ever told to my children is when I've been incarcerated that I'm in college. I try to, both my kids are autistic. My son is all but diagnosed with being nonverbal. He has a feeding tube. I've been there for my kids since day one. This is the longest that I've ever been away from my kids. The longest actually I've ever been away from my kids is when their mother has them. And normally, like I said, it's 1 week I get them 3 days, she gives them 4, and then we alternate. And I definitely understand. I know I had my children before all of this, and I should have took that into more consideration. And I just beg for mercy of the court to just please let me get back home to my children. I can 100% guarantee whatever conditions, whatever probation conditions. I will abide and follow those to the T. I will not have any infractions. There won't be any excuses. It will be nothing. It will be nothing that gets me in front of the court again for anything at all.
Well, here's the part I'm confused with, is that when you were here last time, I told you what was going to happen if you tested positive for marijuana, and you went ahead and used again anyway. Your explanation when you were here the first time, you came out and said you used at the end of February. It was something about you had a part of a gummy or something like that because you were with some people, and so you were concerned with that maybe you were going to test positive at your change of plea, literally a whole month later. This was March 30th. And you did. But then you came back 3 weeks after that and you tested positive again. So you used again. There's no way. First of all, you shouldn't even have tested positive on March 30th. If you truly were being honest with the court when you said how much you used a month earlier and that you were concerned, that would not have come up positive on our screen. But then 3 weeks later you test positive again. You clearly used again after being told what was going to happen. And you did it anyway. And you were told that if you test positive, your bond's getting revoked and warrants being issued for your arrest. That means you're going to be away from your kids. You're not going to be with them. And you made that decision to do that anyway. And now you're asking me to take into consideration your children. And you had a chance to do that, and you didn't do that. Why did you use again?
The only thing I can say, Your Honor, is maybe I can honestly say my right hand of God, from the time that I left, I did not use again. Only thing I can say is maybe it was more, I maybe took more. I didn't say just the gummy.
You could have had as much as you wanted. It's not going to come back positive 7 weeks later on our test. Right? It's not going to come back positive 7 weeks later on our test. If you said you used at the end of February, you tested on April 23rd. Positive. So even if you had a lot more, you could have had a whole bunch more. It wouldn't be positive if that's from end of February.
I can honestly say, Your Honor, I promise you, going forward, I will not. It will be no more infractions. I would do any of the strictest. The strictest.
If you're on probation, you can't smoke marijuana. You can't do gummies. And if it comes back positive, you're going to be in jail. And very well could go to prison then. You can go to prison for that. So, yeah, normally if you use marijuana, under the circle, I guess even now it could be considered legal. But so is alcohol, and you're not allowed to drink alcohol. Mm-hmm. But it would be a minor misdemeanor. Here it's a felony of the 5th degree for you in a sense, because you can go to prison for 12 months if you test positive for marijuana.
I can honestly say, Your Honor, I'm 100% confident if you give me the opportunity to...
I suspect that if it happens, you're going to have some excuse or some explanation. Something horrible happened in your family life and you were stressed because of that, and that's why you did it. That's not going to fly.
I will, in writing, I can put in writing right now that if my test positive again, that I will have no excuses and whatever you like to do. I mean, of course, it's 100% of your, you are in 100% control of the situation anyway, but I won't even say a word.
You're saying that if you would agree to, if you test positive, you would just come in here and say, send me to prison for 12 months?
I can say that, yes, sir. I will put it in writing right now. I'm 100% confident. There would be nothing. It would be nothing that I would do to ever put myself in a position like this again. I'm 100% confident. 100%.
I'm going to save this whole recording just so you know.
I hear you, and that's how confident I am. I'm not
back if you ever come back.
I will never come back here for anything again. I'm 100% confident now, Your Honor. I say that with 100% confidence.
You hear that, Amy? Save this recording right now. Hey, is there anything else you'd like to say, Mr. Battles?
No, sir.
Mr. Mulkey, anything else?
No, I guess I wish my client had made an oral contract with the court on the record regarding a near guaranteed of a maximum prison sentence for a probation violation, but, Your Honor, he seems sincere in what he is telling the court, so time will tell. And again, if that's what he's willing to agree to, again, I would ask the court to consider that, consider what its sentence would be if he violates, but let him out today so he can get back to work tomorrow. And certainly he's given himself some rope, as it were, to for lack of a better vernacular, to hang himself with on that. So for that, I would ask the court to consider not placing him in JTP at this time, see how he does, and he knows what he can be expecting if he comes back again. Thank you.
Thank you. Ms. Mulligan for the State of Ohio.
Your Honor, the state is recommending community control under the terms and conditions that this court deems most appropriate.
Thank you. Well, I've reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the underlying offense, the nature of that offense. I've considered what's been said here in court by the defendant, his lawyer, the prosecutor, the recommendations. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-2911. For the factors in 29-2912, factors indicating the conduct is more or less serious. Nothing stands out factually indicating it's more or less serious. As for recidivism factors, the court finds the defendant violated the conditions of his bond and using marijuana while he was on bond. And I find that he used it after the change of plea as well. That's a factor indicating recidivism is more likely. Factors indicating it's less likely. The defendant has no prior history at all. No juvenile delinquency adjudication, no criminal history, misdemeanor, felony, nothing. He's led a law-abiding life his entire life, I should say. Under 29-2913B1, the offense involves a firearm, which is a factor that overrides the presumption for probation, permits the court to impose a prison term. However, prison is not consistent at the time with the purposes and principles of sentencing, and the defendant is amenable to an available community control sanction. So I'm going to place you on community control sanctions for a period of 2 years. I'm going to order that you serve 30 days in Lake County Jail. You have credit for 23 days. You have 7 more days that you need to serve. Upon your release, then you are not to use any drugs or alcohol. That includes no marijuana use. You shall submit urine tests or any other type of testing that's requested. And you submit that when requested. They have to be negative. A positive screen will result in a violation. Came out, I want any review board contracts for marijuana use.
I'm sorry, Judge, what was that?
It's not a condition. I'm just saying that there's not going to be a review board contract if he's test positive for marijuana, because that shouldn't be happening, according to him. I want you to immediately upon your release get a drug and alcohol assessment and follow whatever recommendations are made for any type of counseling or treatment. You attend 2 AA meetings a week and have a sponsor. To obtain and maintain full-time employment. Under count 2, a mandatory fine is required. I'll impose the minimum mandatory fine, so $565 fine. License suspension is required as well. And the minimum is 1 year. I'll suspend it for 1 year. further condition of probation is he's not to drive without a valid license. And I know that's separate and apart from the suspension. And the reason I do that is that if you were to get stopped and they don't cite you, if someone sees you driving and you're not arrested or cited, you're still in violation because you're not to drive without a valid license. Or valid privileges. If you're legally allowed to drive, that's fine, but you're not allowed to drive without either valid license or valid privileges. Pay court costs and supervision fees. Oh, I know. I'm going to have you get a mental health evaluation as well, because I know there's been some recent issues or concerns there. So get a mental health evaluation and follow whatever recommendations are made for any type of counseling, treatment, or medication, and follow those recommendations. Take any medications as prescribed. Kim, you guys are recommending that supervision be transferred? Or not transferred?
We are, Your Honor.
All right, I'll transfer supervision to Summit County. So what that means, Mr. Battles, is that they're going to supervise your probation. So you don't need to report. You don't have to come to Lake County to report. You'll report in Summit County, wherever that is. But you're still on probation to me. So they're just supervising it for me.
Yes, Your Honor.
So if you violate, they will notify our probation department. We'll issue a warrant for you. You'll be brought back before me, not in Summit County. They're just merely making it easier for you to report, basically, and they'll be taking your urine tests and doing that stuff.
Thank you, Your Honor.
But they're still going to be, you're still on probation to me.
Yes, sir.
Understand that?
Yes, Your Honor. Thank you.
Kim, is there anything else I should be considering?
No, Your Honor.
So, Mr. Battles, you understand all the conditions of your probation?
Yes, Your
All
Honor.
right, I need to advise you, if you fail to comply with any of the conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense, a motion to terminate your community control will be filed. And if it's found that you violated, I could extend your probation up to I'm going to change one thing. Let me think here for a second. Go back, in regards to jail time, on count one, he's being sent, as a condition of probation, I'm sentencing him to 23 days in jail with 23 credit. On count two, the OVI, I'm sentencing him to 30 days in jail with 23 credit. So the additional 7 days is going to be on the OVI. So again, if you violate any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I technically could keep you on probation. I could extend it up to 5 years. I could impose more restrictive sanctions against you. Or I can terminate your probation and send you to prison. It'd be 12 months in prison, so that's what's hanging over your head. And that'd be consecutive to any other sentence that you may be serving at that time for something else, or that you're being sentenced to at that time. You understand that?
Yes, Your Honor.
All right.
Thank you.
Ms. Mulligan, anything else?
No, Your Honor, thank you.
Mr. Mulkey?
No, Your Honor, thank you.
All right, thank you all.
All rise.
Now, we are present in case 26 CR 533, State of Ohio versus Christopher Harkins. We're here for a pretrial. Defendants here in open court. With counsel, Mr. Hector Martinez. State is represented by Assistant Prosecuting Attorney Nicholas Geigrich. I met with counsel in chambers prior to coming out on the bench and discussed the case. Defendant is currently in custody, his bond having been revoked for failure to appear to a prior pretrial that was scheduled in this matter. Subsequent to that, the defendant retained Mr. Martinez. Mr. Martinez previously filed a motion to reinstate bond that was revoked, or excuse me, that was denied by the court. After discussion in chambers, the court will reconsider that ruling and reinstate defendant's bond with the condition that you're going to report weekly to the probate. You can be seated. I don't interpret that as disrespect. You must report on a weekly basis to the probation department. I want you to contact them tomorrow morning. You don't have to go in tomorrow morning, but you can contact them by phone. Ask for Craig Berry. And then you'll set up a schedule with him as to when to appear.
Thank you.
Or whoever he wants you to see, but you'll set it up with him. So make sure you contact him tomorrow. I also want to make sure, let's get a bond condition form, Stan, and have him fill it out. With all the correct information and his contact information, where he's going to be living, and get him a copy of it. We're going to give you that bond condition form. Make sure you have a copy of it. Make sure we have all the right information as to where you're living, what your right phone number is. All right, well, then it's just this. Ms. Martinez, you want to coach here for a second? Stan, we got it. You can fill it out afterwards. You fill it out too then, because we don't even have yours on the other one, right? We got one. We got one for this case. So you'll fill that out. Make sure, give it to Stan when it's filled out. We'll make a copy of it and give it back to you. But you're not to use any drugs or alcohol. That includes no marijuana use. Fail to show up, or you fail to, if you test positive, or if you screw around with a urine sample in any way, your bond's going to get revoked. You understand that?
I understand. Thank you.
Is the other case, Mr. Geigrich, Mr. Geigrich, is the other case a bind over or a secret?
It's a secret case at this point, Your Honor.
So there's no bond in that case or anything?
There is none,
okay.
no.
All right. Aside from that, like I said, we pre-tried the case in chambers. There's no reason to need to do anything else at this point.
I gave him a time.
Hang on one second. Who posted your bond?
My
All
girlfriend.
right, well, there's a bond forfeiture hearing scheduled. That'll be canceled, so you don't need to worry about that. What's your name? Funk was the last name, is that right? Funk, okay. You can disregard that bond forfeiture hearing then.
Thank you.
All right, I think that's it. Anything else, Mr. Martinez?
No, Your Honor. Thank you
Mr.
very much.
Geigrich?
Nothing, Your Honor. Thank you.
All right.